Welcome back. You're watching The Globe. The United States has imposed sanctions on International Criminal Court prosecutor Fatou Bensouda. U.S. Secretary of State Mike Pompeo says in his response to her investigation into whether American forces committed war crimes in Afghanistan. Bensouda was given the go-ahead by the court in March to investigate possible war crimes against the Taliban, Afghan military and U.S. forces. The head of the ICC's jurisdiction, Complementary and Cooperation Division, Pakiso Muchokochocho, has also been blacklisted. Pompeo says that the sanctions will allow for asset freezes and travel bans. He also said that the other individuals and entities that continue to materially support Bensouda will risk exposure to sanctions as well. The State Department has also restricted the issuance of visas for individuals involved in the court's efforts to investigate U.S. personnel. But the department did not name those affected. The United States revoked Bensouda's entry visa last year over the possible Afghanistan inquiry. But under an agreement between the United Nations and Washington, she was still able to regularly travel to New York to brief the UN Security Council on cases that it had referred to the court in The Hague.
In June, the Trump administration authorized the imposition of economic sanctions against foreign persons directly engaged in ICC efforts to investigate U.S. or allied personnel and those who materially assisted in that effort. Today, we take the next step because the ICC continues to target Americans, sadly. Pursuant to Executive Order 13928, the United States will designate ICC prosecutor Fatou Bensouda and the ICC's head of jurisdiction, Complementary and Cooperation Division, Pakiso Muchokochocho, for having materially assisted prosecutor Bensouda. Individuals and entities that continue to materially support those individuals risk exposure to sanctions as well. Additionally, State Department has restricted the issuance of visas for certain individuals involved in the ICC's efforts to investigate U.S. personnel.
The United Nations Secretary General Antonio Guterres has meanwhile expressed concern over Pompeo's announcement through a statement from his spokesperson.
The Secretary General takes note with concern of today's statement by the United States Secretary of State announcing the designation of the prosecutor of the International Criminal Court and the head of the ICC's jurisdiction complementarity and cooperation division pursuant to the U.S. executive order on blocking property of certain persons associated with the ICC. And that executive order is dated 11 June 2020. We continue to closely follow the developments on this matter. Cooperation between the United Nations and the International Criminal Court is founded on their relationship agreement, which was approved by the General Assembly in September of 2004. We will be analyzing any possible implications that this development may have with respect to the implementation of this relationship agreement.
Well, to get a sense of what has pushed Washington to take such measures and the precedent that this decision sets, we're now joined via Skype by international law expert Dr. Innocent Badasu, who joins us live now from Accra in Ghana. Thanks so much indeed for joining us. Good to have you on the program again.
Thank you so much, and good to be here again as well.
All right, so what do you make of Washington's move to sanction the ICC prosecutors? I mean, it does seem a bit extreme.
Yes, first of all, we need to understand the context in which the United States is operating. Increasingly, we have seen the United States creating a hostile environment for international organizations. And the ICC is one of those international organizations that the U.S. is targeting. And then we also need to appreciate that this whole sanction list, it's not surprising at all because the signs have been there. We saw it coming somewhere last year when visa restrictions were imposed. Threats were issued by the then National Security Advisor, John Bolton, and some other high-ranking officials of the State Department. and including President Trump himself. And so this is an escalation of existing strained relations between the U.S. and the ICC. And it is not surprising that they have come to this point of a punitive measure to target individual officers, senior officers of the ICC. And so for me, in as much as this may be shocking the world, this is quite concerning. The point also is that the U.S. has exhibited consistent state practice in terms of rejecting the court's authorization of investigation in the Afghanistan situation.
All right, so I'm just trying to figure out now, can the U.S. on the one hand say we've done nothing wrong, but at the same time we don't want to be investigated?
Right, an important question that you have asked, but what we need to do is to place this question in a certain diplomatic context. As far back as 2000, President Clinton signed the Rome Statute, but failed to secure Senate approval. And then after the elections in the U.S., Bush won the elections, and then one of the first things that he did was to renounce the signature of the U.S. He didn't leave it there. He went ahead to also enact what has become known as the American Service Members Protection Act of 2002. And what that law simply seeks to do was to avoid cooperation with the ICC and also to give the U.S. domestic capacity to use any means necessary and possible to be able to shield American servicemen and women who may be indicted or who may be a subject of investigation of the ICC. And so in a situation where they are detained, even in Hague, it is possible that American forces could invade and be able to retrieve the American personnel that may be held in detention. And so this has become known as the Hague Invasion Law. Now, beyond that also, the American government at the time, led by Bush, went ahead to also initiate moves towards having a bilateral immunity agreement to ensure that American soldiers, wherever they are found, are never surrendered to the jurisdiction of the ICC. And so basically, we need to appreciate this consistent hostility demonstrated by the U.S. towards the ICC. Now, the point is that, yes, if you have nothing to hide, then you should be able to face justice. But it's also a question of state sovereignty. Now, Americans have consistently indicated that the ICC is illegitimate, the ICC is ineffective, and the ICC is a dangerous institution that undermines U.S. foreign policy choices and national security considerations around the world. And so it is important to understand that what the Americans simply are asking for is that where we think that there are issues to be resolved, they must be resolved through the domestic legal systems of the U.S., which they believe is robust, it's fair enough to be able to guarantee the judicial freedom of all persons, whether victims or perpetrators of crimes against humanity.
All right, so the ICC intervenes where a country cannot or refuses to prosecute crime. And I suppose the question that flows from what you've just said, does America have a track record of indicting its own where there has been wrongdoing by army personnel in foreign territories?
Yes, what we should appreciate is that sometimes some of these investigations and punitive measures at the domestic level are done by the military court, the martial court. So you would hardly sometimes come across this. Now, there are instances where American service commanders have been held accountable because even American citizens themselves have gone to activate judicial mechanisms available to them. And other citizens have also used the U.S. systems to be able to hold individuals accountable. What the Americans are basically seeking is to avoid trials, is to avoid being a subject of international investigations. But the understanding is that the domestic system is robust enough to provide that kind of justice that is required. And so, yes, there are a few instances where America has been able to live up to expectations. But we also have several instances. In this case, we are talking about Afghanistan, where very little has been done to ensure that the gross human rights violations, the abuses and torture that took place in those places are also investigated, properly investigated, and then perpetrators brought to book and fairly held accountable.
All right, so another conundrum that I hope you can help us explain. So you've got Russia, China, the United States who don't want anything to do with the ICC. However, sitting on the Security Council, they refer cases to the ICC, such as Omar al-Bashir. How does that work?
Yes, what we should understand is that there are several mechanisms within which the ICC can intervene. One of them is Security Council referral. So, rightly so, you pointed, Russia, China, and the U.S. may not be state parties, may not have signed on to the Rome Statute, but by workings of the UN Security Council, they have shown some kind of cooperation. For instance, if we take a specific case of Ntaganda, Bosco Ntaganda, that was convicted by the ICC, he surrendered himself to the U.S. Embassy in the DRC Congo, and it was the U.S. Embassy that finally transferred him to the court for prosecution to take place. And so there are instances where some of these superpowers, some of these big players on the international legal system have been able to somehow cooperate with the court. But what in particular the U.S. is seeking to reject is to subject its citizens to transnational judicial mechanisms like that of the ICC.
So what precedent does this set that a country can impose sanctions on ICC prosecutors if they so wish?
Now, it is important to raise the point that this is completely unprecedented. And it's going to create all kinds of difficulties even within international law. Now, from one side of the debate, we need to understand that the U.S. as a legal entity has every right and capacity to be able to enforce administrative rules and regulations or domestic law that has a transnational effect. So in this case, it is a control of an asset. So any asset that is owned by these individuals within the jurisdiction of the U.S. could be under the control and management of the U.S. and preventing the individuals from having access to these properties. What is unclear to us is the amount of resources or property that is being held by these individuals in the U.S. And so in a situation where they do not have substantial resources or, if you like, property in the U.S., then I am thinking that the sanction would be counterproductive. But knowing very well the United States, they would want to weigh the options of its effect, the effect of the sanctions. So I am trying to give them the benefit of the doubt that they really understand that some kind of substantial property is being held by these individuals in the U.S. Now, what this means is that we have to look at state parties. Now, unilateral sanctions are part of international relations and international law. While there is no consensus over how unilateral sanctions should be applied, we have seen it in several instances. What is shocking about this particular scenario is that you have a high-ranking international agent like the ICC prosecutor who enjoys some amount of functional immunity to be able to carry out her duties, being under sanctions. Now, sanctions also imposes restrictions on you. And these restrictions undermine how effectively you can carry out your duty. So my interpretation of all of this is that Madame Bensouda is almost leaving because the process of electing a new ICC prosecutor and some other judges have commenced. And so her remaining term is going to just be a hang-on. She's not going to be able to really do anything effectively. Now, what this means is that there are other people who support the court. And so you begin to see them demonstrate support for the court, as it happened in the past, somewhere last year, when the National Security Advisor threatened to impose sanctions. So here we are. I am quite confident the European partners of the court will reinforce their commitment to the shared values of the court and support the court such that we would be able to function. My fear is that the two individuals may not be able to carry out financial transactions because some of these things may have to be approved by U.S. institutions and agencies. And to the extent that the enforcement must be done by the U.S. Treasury Department, this is going to be effectively implemented. So certainly, there are severe consequences for these sanctions.
All right. Dr. Badasu, we're going to have to leave it there. Thank you so much indeed for your insights, as usual. Very interesting case, and let's hope that a precedent that we can't come back from is not being set here. Thank you so much indeed.